Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hello everyone, hope you're all enjoying the summer. On this month's pod, I've got a couple of Court of Appeal decisions to run through with you, as well as an update on changes to the UK's prospectus regime. So let's get into those cases. And the first one is concerned with directors' duties. So the Court of Appeal has overturned a High Court decision ruling that a director's duty to act in good faith includes as a core fiduciary duty a requirement that the director act honestly towards the company. And the court went on to say that the test for honesty is not purely subjective, but must also be assessed objectively by the standards of ordinary decent people. So I think this decision provides a pretty clear warning to directors that they cannot rely on their own subjective belief as a shield for what is objectively dishonest conduct. And even if a director believes that their actions will benefit the company in the long run, deliberately deceiving the board will almost always be inconsistent with a director's duty to promote the success of the company. Now, that duty is set out in the Companies Act in section 172, which provides that a director must act in the way they consider in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. And in doing so, the director must have regard to a non-exhaustive list of factors, which includes things like the likely long-term consequences of any decision and the need to act fairly as between company members. That duty to promote the success of the company is just one of the statutory duties that directors owe to their company. There are lots of potential consequences for breaching those directors' duties, including that the breach could mount to unfairly prejudicial conduct, and it could also result in personal liability or even disqualification for the relevant director. So, in this case, which is Saxon Woods Investment Limited and Francesco Costa, the claimant was Saxon Woods, and Saxon Woods was a minority investor in a company, and Saxon Woods brought a unfair prejudice petition against the company, alleging that the company had acted in breach of a requirement in a shareholders agreement, and that obligation was to work together in good faith towards an exit by a specified date. So Saxon Woods alleged that Mr. Costa, who was the company's chair and majority shareholder, was responsible for the prejudicial conduct, and that also Mr. Costa had acted in breach of his fiduciary duties to the company. So at first instance in the High Court, the court concluded that Mr. Costa had caused the company to breach its obligations under the shareholders agreement by failing to work in good faith towards an exit and by not giving good faith consideration to exit opportunities. And that, the court said, amounted to unfairly prejudicial conduct. But the High Court went on to conclude that Mr. Costa was not in breach of his fiduciary duties as a director. And the judge's reasoning here hinged on a subjective test for Section 172. So the question was whether the director honestly believed that his act or omission was in the interests of the company. And the judge found that in this case, Mr. Costa had sincerely believed that he was, in fact, acting in the best interests of the company and therefore had acted in good faith in accordance with his duties as a director. And that was despite the fact that Mr. Costa had deliberately misled the board and concealed relevant information about potential exits from that board. So that was the High Court decision, and then both sides actually appealed that decision. And now the Court of Appeal has found that the High Court's approach to Section 172 was fundamentally flawed, and it held that Mr. Costa had acted in breach of his duties to the company. So the court clarified that the requirement to act in good faith under Section 172 includes a core fiduciary duty of honesty. So, departing from the High Court's purely subjective test, the Court of Appeal applied the established legal principle that honesty and dishonesty requires an objective assessment of the director's conduct in light of the facts they knew and believed at the time. And that meant that a director's belief must not only be genuinely held, but also objectively considered honest by the standards of ordinary, decent people. The court ruled that deliberately deceiving the board of a company must either always or almost always be inconsistent with a director's duty under Section 172. And on that basis, Mr. Costa's misleading behaviour clearly constituted a breach of his fiduciary duty under that section. His subjective belief that his actions would actually ultimately benefit the company did not negate the dishonesty of his conduct. So the Court of Appeal upheld the High Court's finding that Mr. Costa's actions had amounted to unfairly prejudicial conduct, but as a result of its ruling on Mr. Costa's breach of duty, the Court of Appeal concluded that it would be unjust to leave Saxon Woods as a minority shareholder in a company controlled by someone who had demonstrated a willingness to disregard shareholder rights and mislead the board. So, as a result of that, the court ordered Mr. Costa to buy out Saxon Woods shares at their open market value as at the 31st of December 2019, which was the date by which the company should have been sold under the exit provisions in the shareholders agreement. So I think this Court of Appeal decision provides useful lessons for directors relating to their duty to promote the success of the company. Primarily, the case clarifies that acting in good faith goes hand in hand with the requirement to act honestly, and honesty will be assessed both subjectively and objectively. So even if a director genuinely believes that their actions will benefit the company, they may still be in breach of their duties if they conceal information from the board or deliberately mislead them. And although the court accepted that there may be exceptional circumstances where this behaviour would not amount to a breach, to be honest, I think it's pretty difficult to think of what those circumstances might actually be. So, if you're a director, then I think you would be well advised to ensure that all relevant information is divulged to the entire board, and that major decisions by the board are always taken collectively. And as always, board decisions should be properly documented and evidence of best interests, what's in the company's best interest, retained in case there is future scrutiny of those decisions by the courts, as there was in this case. So, the second case, back in the Court of Appeal again, saw the Court of Appeal this time uphold the High Court's interpretation of compulsory transfer provisions in a company's Articles of Association. And the case turned on the meaning of the words in that capacity as set out in the transfer provisions, and as is often the case, illustrates the importance of using precise language when drafting documents such as Articles of Association. So, in this case, the articles of a group holding company had a provision in them dealing with leavers, and the provision provided that if any employee member shall cease for any reason to be employed as an employee, director, or consultant of a group company and does not continue in that capacity in relation to any group company, then a transfer notice should be deemed to have been served on the date of such cessation. Now, the key issue to be decided here was the date on which Mr. Truman, who was a director of the holding company, was deemed to have served a transfer notice under the articles. Now, Mr. Truman had also been an employee member, as it defined in the articles, and a director of the company's subsidiary, but he was dismissed as an employee of the subsidiary in October 2022, and he was then removed as a director of that company, the subsidiary, the following month, so October, November 2022. But crucially, he continued as a director of the holding company until his resignation in May 2023. Now, the holding company argued that the words "in that capacity" in the relevant provision in the articles referred to the specific capacity in which Mr. Truman, as an employee member, ceased to be employed, i.e., in October 2022. But in contrast, Mr. Truman argued that the words referred to any of the three capacities mentioned in the provision, so an employee or a director or a consultant. So remember, he had continued as a director of the holding company until May 2023. So Mr. Truman said that the transfer notice should not be deemed served until that time. And that interpretation would result in Mr. Truman receiving fair value for his shares, which was a significantly higher amount than the market value that he would have received if the holding company's interpretation was correct. So that's why they were having this disagreement about the meaning of the articles. Now, in the High Court, the first instance decision, the court agreed with Mr. Truman's interpretation, finding that the word employed in the transfer provisions was not used in the kind of strict sense of being an employee, but instead it was used much more broadly to cover being engaged as either an employee or as a director or as a consultant. And therefore, the reference to "in that capacity" related back to those three different capacities, meaning that the provision didn't apply when Mr. Truman ceased to be employed by the subsidiary, but continued as a director of the holding company, because he has continued in a capacity. And the judge said that that was a more natural reading of the wording, and also that it accorded with commercial common sense. So the holding company appealed that decision. But when it came before the Court of Appeal dismissed the appeal and largely agreed with the High Court's original reasoning. So the Court of Appeal acknowledged that the appeal here turned on the meaning of that phrase "in that capacity." And it confirmed that when you're thinking about that and when you're considering the meaning, you had to do that by reference to the Articles of Association as a whole, by reference to any extrinsic facts about the holding company or its membership that would be reasonably ascertainable by someone reading the company's articles and public filings at Companies House. And you had to also do it by commercial common sense. So the Court of Appeal held that although the use of the singular "that capacity" was capable of referring back to one or other of the specific capacities in which an employee member might be employed, it was equally capable of referring to the single overarching capacity of being employed, whether that was as an employee or a director or a consultant. And that second interpretation, the court said, made more commercial sense because it aligned with the default position that, in the absence of agreement, shares could be sold at fair value and that market value was an exception. So the court found that the holding company's interpretation would lead to commercially illogical outcomes, such as forcing a sale of shares at a lower price if an employee ceased to be employed full time, but still continued to be involved in the running of the business, say, as a consultant. So, what's the lesson from this case? Well, it won't be the first time that you've heard me say it, but I think it is a stark reminder of the importance of clear and precise drafting in all contractual documents. And the ambiguity over the meaning of in that capacity in the Articles of Association led to significant financial implications and also protracted litigation for all of the parties involved. It is common for Articles of Association to contain compulsory transfer provisions so that if a shareholder who's also engaged in the business leaves, they don't benefit from any increase in the company's value after they've left, where they won't have contributed to that increase in value. So, what's the lesson here? Well, I think companies need to ensure that their articles very clearly define what constitutes a cessation event in the context of those compulsory transfer provisions and specifying whether it applies to a single role or to all engagements within the group. If they don't do that, then I think this case suggests that the courts will lean towards interpretations that uphold commercial common sense whilst potentially protecting employee shareholders from being forced to transfer shares at an unexpected undervalue. So they can be forced to transfer those shares at an undervalue, provided that's very clear in the Articles of Association and it's clearly the terms on which that employee member signed up to getting their shares, if you like. Okay, finally, the Financial Conduct Authority, the FCA, has published a policy statement confirming its final rules to implement the new prospectus regime in the UK. So the new rules and new statutory regulations are going to provide the new regulatory framework for public offers and admissions to trading in the UK, replacing the current prospectus regulation rules. And the hope here, the reason we're having all of these new rules and regulations, is that it's going to make it easier for companies to raise capital in the UK and that it will also reduce costs. Now, the new rules aren't expected to come into effect until the 19th of January next year, 2026. So we have a few months to prepare, but it is going to be quite a significant change. So it's a good idea to get up to speed with what those rules are going to be. So there was a UK listing review that took place over the last few years and several public consultations. And following that review and the recommendations that came out of it, there were new regulations made actually back in January 2024. They're called the Public Offers and Admissions to Trading Regulations. And those regulations provide the framework for a new UK public offers and admissions to trading regime. So, under the regulations, an offer of securities to the public will be unlawful unless an exemption applies. So, you've got to get within an exemption if you're making an offer of securities to the public. Now, lots of the current prospectus exemptions are going to be carried over, but the regulations also include an important new exemption that applies when securities are to be admitted to trading on a regulated market or what's called a primary multilateral trading facility, an MTF, such as AIM. The AIM market is an MTF. So, in another significant change, the regulations delegate to the FCA the detailed rule-making powers for the new regime. So that includes powers to set rules on when a prospectus is going to be required, where a company is seeking to admit securities either to a regulated market or a primary MTF. And then, as well as when a prospectus is required, also what information should then be included in that prospectus. So The FCA had various consultations on proposals for the new regime, and like I say, it's now published the final version of its rules. And it has maintained the bulk of the kind of current prospectus requirements that apply to an IPO on a regulated market, including around the contents of the prospectus. But there are going to be some significant reforms, so let's just run through a few of those. So, in a major change, the threshold at which an existing listed issuer must publish a prospectus for a further issue of transferable securities is going to be increased to 75% from the current 20% threshold. So, quite a significant increase there. And that change should exempt many issuers from the requirement to publish a prospectus and also hopefully make it significantly easier and also cheaper to raise capital in a secondary fundraising. So, in another change, the 6-day rule, which requires a public offer prospectus to be made available to the public at least 6 working days before the end of the offer, is going to be reduced to just 3 days. And it's hoped that that change will encourage issuers to include a retail offer in their IPO. The content requirements for a prospectus summary have been relaxed so that detailed financial information will no longer have to be included, and issuers will be able to cross refer instead to other sections of the prospectus. Another change, the FCA has defined the types of forward-looking statements that will qualify as protected forward-looking statements. Now, these protected statements will be subject to a reduced liability threshold based on recklessness rather than the current threshold of negligence. And again, it's hoped that that change will encourage companies to include more useful disclosures in a prospectus. And then in another change, the FCA has confirmed that primary MTFs that allow retail participation, so that would include AIM, for example, must require the publication of an MTF admission prospectus on all initial admissions and reverse takeovers, subject to some exceptions. It's not going to have to be approved by the FCA, but an MTF admission prospectus will be subject to the same statutory responsibility and compensation provisions as apply to a regulated market prospectus. Operators of MTFs will determine the relevant prospectus approval process and content requirements, and they'll also have discretion as to whether a prospectus will be required for secondary issues. So, as I say, the new regime is expected to take effect on the 19th of January next year. In the meantime, the FCA has indicated that it will consult and issue guidance in various areas, including in relation to those protected statements that I mentioned, but also working capital statements and climate related disclosures. And then there's going to be further work during the rest of this year and 2026 to delete or update other prospectus related material in the FCA's knowledge base. So, bit of a highlight there of changes coming down the track that we're going to need to get used to from the new year. That's it for today. Hope you found that interesting, and I'll see you next month. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.